Well, good afternoon, everyone, and welcome. My name is Tim Blotz from Fox 9, and we welcome you to our streaming coverage on fox9.com and on our YouTube channel of the federal civil rights trial for the three former Minneapolis police officers who assisted in the arrest of George Floyd. In opening statements today, they've already begun. The three officers, J. Alexander King, Thomas Lang, Tu Tao, are all accused of depriving George Floyd of his civil rights on May 25th of 2020. Essentially, they're all accused of illegally seizing George Floyd and depriving him of his liberty without due process. We should note here that Derek Chauvin, the fourth police officer on the scene that day, is now serving a 22-year prison sentence for Floyd's death. And Derek Chauvin has also already pleaded guilty in his federal civil rights case. Rob Olson is at the federal courthouse in St. Paul and joins us now with day one of the opening statements in this case. All started this morning with the prosecutor in this case, Samantha Treppel, laying out the federal case that asking the jurors that we ask you to hold these men accountable for choosing to do nothing. That's essentially their argument, right, Rob?
Yeah, it is. And she repeated the phrase multiple times that in custody also means in your care. In custody is in your care. That was kind of a key theme of her opening statement. Again, these are not called arguments. They're opening statements, closing arguments. So there's a distinction there that at the beginning you're supposed to state facts and what you will basically a preview to what you will hear, and then at the end you can argue. There were a couple of objections during her opening statement from defense attorneys that she was getting too argumentative, and the judge overruled that. One of those objections even said, I'm going to call for a mistrial, knowing it's early to do that, but just to kind of make a point. And the judge said, overruled, but yes, she was getting a little bit too argumentative for my comfort in this court. But she basically said that these men, and she recounted the timeline here and how much time was spent with Derek Chauvin kneeling on George Floyd's neck and pointing out that these men had a duty in the Constitution and under Minneapolis police policy to intervene when they see an excessive use of force and to provide life-saving aid. And they said, minutes passed after George Floyd stopped talking. They could no longer find a pulse, and yet nothing was done until the paramedics got there. That was her, kind of the gist of her opening statement that went for about 40 minutes or so, Tim.
Now, right after that, we've had the attorneys from at least two of the former officers laying out their opening statements and how they intend to defend this case, all beginning with Tu Tao and his attorney, Robert Paul, who essentially said that the fact that something ends tragically does not make this a crime.
Yeah, and much of his opening statement, again representing Tu Tao, he went through a lot of logistics for the jurors here, using maps of the city, maps of that intersection where the cars were, kind of going through the timeline in terms of the time of the call and what happened. And so much of his, you can sense that perhaps the defense attorneys are kind of dividing and conquering and presenting a lot of information in opening statements. So much of his focused on that, logistics, but he did end it with saying that, yes, I mean, the prosecution here, the U.S. government, must prove that these men acted willfully. That's a term or a word that you're going to hear a lot here legally. Willfully. Did they willfully deprive him of these civil rights? And he said no. In the end, the evidence will show that they did not. And just because, as you mentioned, just because it's a tragedy does not make it a crime. And that's the way he concluded his opening statement before going to the second defense attorney, Tim.
And in the second defense attorney here, Thomas Pluckett, who's representing J. Alexander King, essentially made that same argument here, that in order for the jury to convict, they must prove that willfulness was actually conducted here. And he kind of laid out a number of points here that he was trying to argue that these three officers didn't have enough training in trying to turn the tables here in basically saying the Minneapolis Police Department is in fault for their training procedures and putting these officers out there who just weren't prepared for it yet.
Yeah, and that was, again, taking over the kind of the baton, I guess, from the first defense attorney's opening statement, who laid out a lot of the logistics. Then Thomas Plunkett went more into stating what they will be looking at here, which is calling into question the Minneapolis Police Department's policies and its training, and whether that was adequate. He pointed out that it was now former Police Chief Medario Arredondo who wrote a duty to intervene policy the year before he became police chief. But Thomas Plunkett says that they will call up trainers who will say that intervention is little more than a word on a PowerPoint. So he's going to definitely call the training into question. He's going to call the command structure into question as well, noting that Derek Chauvin was a field training officer for these rookie police officers, and that they were just a few shifts into their job, and that the way that the command structure is set up is that the field training officer has a lot of authority over these rookies, and so clearly they will try to set the evidence here that that played a huge role in their lack of response here. And again, also hitting on this idea of, were they willfully doing these things that they're charged with.
Coming up here later this afternoon, when the court reconvenes at 2 o'clock, we're going to hear the opening statement here from Attorney Earl Gray, who's representing the third officer, former officer in this case, Thomas Lane. Attorney Gray is someone that many in our audience will recognize. He most recently represented Kim Potter, who is the former police officer who is just convicted here in Brooklyn Center in the accidental shooting, that happened last year, and also represented Philando Castile in his particular case, didn't represent Philando, but represented the police officer in the shooting death of Philando Castile. He is someone that a lot of people will be familiar with, Rob.
Yeah, he's well known. He's represented, as you mentioned, other police officers when they have been charged. So he's certainly got a high profile among, certainly in the local legal community and lawyers in the Twin Cities. He's been doing this for quite a long time here, and he was one of the defense attorneys that actually spoke shortly after these men were charged. These former police officers, and he spoke specifically about Lane's actions here, but basically saying again that his officer or his client did speak up, did say, hey, should we check his pulse, or should we roll him over? Actually, should we roll him onto his side? And that's something the prosecutor really spent a lot of time on, that they're trained to roll people onto their side to prevent any problems, and that Thomas Lane is the one who did ask that twice and was told no. And that is why Thomas Lane is not charged with one of the two charges here. All three men are charged with failing to provide aid, but only two are charged with failing to intervene. Thomas Lane is not, because he did ask, should we roll him over? So you'll probably hear a lot too from Earl Gray that he made those statements and was overruled, and in the way that the structure is set up, that he probably felt that he couldn't say more without jeopardizing his status as a rookie officer. But again, that comes after lunch, so we'll see what tactic that Earl Gray takes in his opening statement.
Rob, you're eyes and ears for us there in the court, and I'm curious to know, how similar were the two arguments between the attorneys here in the first two cases, first two defendants of J. Alexander King and Tu Tao, because essentially they're charged with the same thing.
Yeah, but very different, as I kind of laid out before, is that Robert Pauley kind of went through a lot of setting the scene of the events as they occurred that morning, very kind of just step by step before getting any kind of opening statement. And again, his statement there, after he went through that, all of that logistical timeline events as they occurred, so he just basically saying the evidence will not be there to prove they acted willfully. Then it was Thomas Plunkett who went more into the kind of attack mode and setting the stage that they will go after the Minneapolis Police Department's training and its policies and its command structure. So very different here. One sets the scene, The other one kind of takes it into the tactic that the defense will be employing, and we'll see which way Earl Gray then goes with the third defense opening statement this afternoon.
And Rob, we need to let our viewers know that and remind them that this is a federal case, federal civil rights trial, a U.S. federal district court in St. Paul, and no cameras are allowed. So we can't even show you any kind of video that's taking place in the courtroom, which creates a different dynamic for us reporting this, but we also want to manage the expectations of our viewers here too.
Yeah. This is a state where we've not had cameras in the courtroom until the recent years, and that is at the judge's discretion. But that is in state court, that is in county courtrooms in which they are trying out, for transparency reasons, having cameras in court. But in federal court, nope, no cameras in federal court, and that is just not an option here. So it's kind of back to the technique that we've been used to for many, many years prior to the recent years in Minnesota anyway, which is, basically taking notes, and you have a sketch artist. Mm-hmm. In terms of what we can see here is a closed circuit feed. There's only a handful of reporters that rotate through the courtroom each day, and the rest are watching on closed circuit. You see the judge and you see the attorneys at this point, and basically then through the trial we'll be able to see the witness stand, but you can't take any pictures of them, just sketches once again for this trial.
And Rob, this might be a good point to remind our viewers listening in, viewing in from here in the state of Minnesota, that if you are anticipating on going down to the courthouse and watching the proceedings or seeing what there is to see, there's really not a lot to see because security is very tight around the St. Paul federal courthouse right now.
Yeah, very tight around here. The road closed in front, limited access to this building, and very tight security, which is why, we all have to wear these special media credentials just to get in the building here. So, very different, a very different scene out here.
All right,
very
Rob
quiet
Olson.
too.
Rob Olson coming to us from Federal Courthouse in St. Paul. We're going to wrap up this coverage here and remind you that we will be coming back to you every day at about this time during the lunch break to go to Rob and have him update us on everything that's happening in court so far. Again, things will take off again here at about 2 o'clock after they finish the lunch break. And the attorney for defendant Thomas Lane will actually take the podium and lay out his opening statements in this case. That will be attorney Earl Gray, and we will have a complete wrap-up tonight of everything going on in court on Fox 9 News at 5, and of course on fox9.com as well. On behalf of everyone here at Fox 9, I'm Tim Blotz. Have a great afternoon.